Hello everyone. Now we will talk about the partnership contract, which is also known as the Articles of Partnership. To start, a partnership contract is basically a legal document that outlines the terms, conditions, and agreements between business partners. Now, while it's true that partnerships can be formed just through a verbal agreement, it's highly recommended to have everything written down. Why? Because having a written agreement helps avoid misunderstandings or disputes in the future. This kind of contract clearly defines everything from responsibility to finances. So, if problems come up, it's easier to resolve them. And for better legal protection, it's always a smart move to have a lawyer help draft the contract when you're starting a business partnership. Now, when is this contract executed and what is it for? It's executed before the actual partnership starts operating, meaning this is something partners agree on and sign before doing any business together. The purpose is to make everything clear. It states things like who's responsible for what, how much capital each partner will contribute, how profits and losses will be shared, and how liabilities are handled. Basically, this document acts as a guide for the entire partnership. It helps all partners know their roles and obligations, and it sets the rules for how the business will be managed, especially when it comes to decision making and finances. That's why a partnership contract is so important. It lays the foundation for a smooth and fair partnership.
Hello everyone, I will be discussing the parties and obligation and the description of the articles or contract of a partnership. Now let's go first to the parties and obligation. Who are the parties in this contract? In a contract of partnership, the parties involved are called partners. These can be individual or legal entities who agree to contribute things like money, property, labor, or skills to a common business venture with the intention of sharing its profit and losses. What are the obligations of the parties? The specific obligations of each partner can differ depending on how the partnership is set up. Now we have different types of partners. We have general partners. They have full control over management and operations and are personally liable for the debts and obligations of the partnership. This means that if the business cannot meet its financial commitments, their personal assets may be used to cover those liabilities. Next, we have the limited partners. On the other hand, these partners typically contribute capital but do not take part in the daily management of the business. Because they do not engage in management, their liability for the debts and obligation of the partnership is limited strictly to the amount of their investment. This means that if the business loses money or get into a legal trouble, the personal belongings of money of limited partners are safe. The only risk is losing the amount they originally invested, which makes this setup attractive for people who want to invest in a business without putting their personal finances in danger. There are also silent partners. These are partners who invest in the business without taking an active role. We also have secret partners who participate in operation but whose associations with the partnership is not made public. Lastly, we have nominal partners. These are individuals who don't put any money into the business or take part in running it. Instead, their role is mostly about having their name linked to the partnership. The main reason for including a nominal partner is to help improve the business reputation. By having their name associated with the business, it can make the partnership look more reliable or well known to customers, investors, or to the public. Now, let's go to the description of contract. What did the parties agree on? In this contract, the parties agree on various key aspects that govern the relationship and the operation of the business. Now, these are the things that the parties agree on. First one is the purpose of the partnership. This defines the business or project that they intended to pursue. Next is the capital contributions. The parties decide on what each partner will contribute to the partnership, whether it's money, property, services, or expertise. This establishes the financial and resource foundation of the partnership or the business. Third one is the profit and loss sharing. This agreement outlines how profit and losses will be shared among the two partners. This could be in proportion to each partner's investment or some other agreed upon method. Next is the management and control. The partners agree on who will manage the business and how decisions will be made inside their business. Some partners some partners may take a more active role in running the business, while others have a passive role. Second to the last is the liabilities and responsibilities. The contract defines the legal and financial responsibilities of each partner. In most partnerships, all partners are responsible for the debts and obligations of the business, but the level of responsibility can vary depending on the type of partnership. Lastly is the exit strategy and termination. The agreement covers how a partner can exit the partnership and what happens if the partnership needs to be dissolved, including the distribution of remaining assets. Now, those are the description of contract and the parties and obligation of the article or contract of a partnership.
Hello everyone, in this video we'll be discussing the elements of contract, where we can find them within a contract document and the legal implications that come with such agreements. Understanding these elements is essential, especially when analyzing how agreements are formed, upheld, and sometimes extinguished. A valid contract is built on three essential elements: consent, object, and cause or consideration. First, consent. Consent is a mutual agreement between the parties entering into the contract. In legal terms, this means both parties freely and knowingly agree to the terms. This is usually demonstrated through narratives or statements from both sides, clearly expressing their willingness to enter into the contract. In a case, this becomes preponderant evidence that both parties truly understand and support the agreement. Second is the object. The object refers to what the contract is all about. It can be a business partnership, a project, or a specific item or service being exchanged or agreed upon. The object must be lawful, possible, and definite. This shows what the parties are agreeing on, and without a clear object, a contract cannot stand. Third is the cause or consideration. This is the reason why the parties are entering into the contract. It refers to the benefits they intend to gain, like profit sharing, joint success, or capital contributions. We can usually find this in the sections of the contract labeled capital contributions and profit and loss sharing. Beyond the three main elements, contracts also include other critical elements such as roles of the partners and the terms and conditions. The roles of the partners are clearly identified in the contract. Each partner's rights, responsibilities, and limitations must be stated to define their authority and obligations within the agreement. The terms and conditions refer to the negotiated clauses, and it is what each party is agreeing to do or receive. This may include timeliness, payment schedules, penalties, or renegotiation clauses.
In our sample articles of partnership, we can identify different kinds of obligation that are clearly stated in the contract. First, we have real obligations under Article 6 about capital contributions. Each partner is required to give a specific amount in cash: 195,000 pesos, 200,000 pesos, and 500,000 pesos. Since this involves giving money, it's considered a real obligation. Next is a personal obligation found in Article 9 under Management. Annalie M. Quijado is assigned as the general manager, and she's expected to handle specific duties like making decisions and managing the company. This obligation is personal because only she can perform those responsibilities. We also have a joint obligation in Article 7, where the profits and losses are divided based on how much capital each partner contributed. That means each of them shares in the obligation depending on their investment. Lastly, There's a legal obligation under Article 10, which says the partner agrees to change the name of the business if it conflicts with an existing registered name. This shows that they're also responsible for following legal rules and requirements. So overall, this contract shows that each type of obligation, real, personal, joint, and legal, helps define the role and responsibility of every partner in a clear and legal way.
Now, let's move to the legal implications and other related principles that affect contracts. First is agreement. The foundation of any contract is the agreement itself. Without agreement, no contract can exist. It is the basis for determining whether obligations are violated or upheld and includes the essential subject matter of the deal. Next is liability. In business partnerships, especially in general and limited partnerships, liability differs. General partners have unlimited liability, meaning their personal assets can be used to cover debts. Next, limited partners are only liable up to the amount of their investment. This distinction is critical as it defines the risk level and protection each partner has under the contract. Next is the fiduciary duties. Partners are expected to uphold fiduciary responsibilities, to act with loyalty, good faith, and fairness. This means avoiding self-dealing, conflicts of interest, and always working for the benefit of the partnership. Next is the extinction of obligation. Contracts and obligations don't last forever. They may end through payment, fulfillment of duties, or a mutual agreement. Understanding how obligations end is important in determining the duration and limitations of legal responsibility. In summary, every contract must contain consent, object, and cause, alongside clear roles, terms, and legal implications such as liability and fiduciary duties. These not only ensure fairness but also protect the interests of both parties involved. Thank you for watching, and I hope this helps you better understand the legal framework and responsibilities found in contracts.
Now let's talk about absolute deed of sale versus conditional deed of sale. So in the aspect of nature of sale, absolute deed of sale is unconditional, full transfer of ownership upon execution. For conditional deed of sale, it is conditional. Transfer of ownership is subject to fulfillment of certain conditions. On to ownership transfer, immediate upon signing and delivery, that is under absolute deed of sale. Now under conditional deed of sale, it is deferred until a condition is fulfilled. For obligation, buyer pays, seller delivers and transfers title, that is under the absolute deed of sale. Now if you go on to the conditional deed of sale, its seller retains ownership until condition is met. For example, a full payment. For risk of loss, under absolute deed of sale, shifts to buyer upon delivery. Now under conditional deed of sale, remains within seller until the condition is satisfied. For unique provisions, no suspensive or resolutory condition is under absolute deed of sale, and for conditional deed of sale contains a suspensive condition. For example, a full payment that must occur before ownership is transferred. Now, for contract of sale versus contract to sell. For the aspect of transfer of ownership, immediate upon agreement and delivery, and deferred. Deferred ownership is reserved by the seller, that is under contract to sell, while the other, immediate upon agreement and delivery, is under contract of sale. For type of obligation, reciprocal obligations, payment versus delivery, that will be under contract of sale. Now under contract to sell, seller has obligation to sell in the future upon condition. Title transfer, title passes immediately under contract of sale. Title passes only after fulfillment of condition under contract to sell. Default by buyer, seller may demand payment or rescission under contract of sale, while on the other hand, seller is not obliged to transfer ownership if condition is not met under contract to sell. Unique provisions is full execution leads to consummated sale under contract of sale, and under contract to sell, condition precedent delays sale, often full payment of financial approval. For conditional sale versus contract to sell, The aspect of conditional type. Under conditional sale, sale already exists but subject to suspensive resolutory conditions. Under contract to sell, no sale yet, only a promise to sell upon a fulfillment of a condition. Ownership transfer transfers up after the condition occurs or may be rescinded. Ownership never transfers unless condition is met under contract to sell. Now binding effect. Sale is perfected but not consummated. Not a sale yet, only a preparatory contract under contract to sell. Legal remedy for buyer. Buyer may sue for a specific performance or rescission under conditional sale. Now, contract to sell, buyer cannot demand transfer until the condition is met. Unique provision. Contains condition affecting the effectivity of the sale is under conditional sale. Now, under contract to sell, contains a promise to sell, not a perfected sale.